Do you want to grow cannabis for your private use but lack any land for cultivation? Do you use or have you considered using a cannabis grow club? Hi, I'm Simon Dippenal and I'm an attorney. If you answered yes to these questions, a recent High Court judgment may cause you to think again. The Haze Club, or the THC for short, is a cooperative arrangement where individuals bring their own seeds to be cultivated communally by horticulturalists. They pay a fee for the service and receive their own plants harvested and dried when ready. Now, technically, or so the club claims, no cannabis is bought or sold. The Haze Club premises were raided in October 2020, and the plants growing there were all seized. Owner Neil Liddell and an employee were arrested. The Haze Club appealed the case in the Cape Town High Court. Liddell relied on the 2018 Prince ruling, which found that it was unconstitutional for the state to criminalize the possession, use, or cultivation of cannabis by adults for personal consumption in their own homes and properly designated places. The state claimed, by contrast, that the club did not operate in a private space and therefore was breaking the law. Now, Judge Slingers ruled against the Haze Club. Her view was that the Grow Club model, operating in the absence of statutory or legal regulations and guidelines, could have the practical effects of legalizing dealing with cannabis. If you use a Grow Club to cultivate cannabis for private use, you're effectively outsourcing your right to grow cannabis, and the law as it stands does not allow for that. An appeal is likely. The Haze Club is only one of many Grow Clubs that have sprung up in the wake of the 2018 Prince decision. The attorneys who represented the Haze Club described the ruling as, quote, a narrow interpretation of the right to privacy, what constitutes a private space, and the limitations on private cultivation of cannabis as envisaged by the Constitutional Court in Prince, unquote. However, Judge Slingers felt it was beyond the remit of the court to interpret the law to this extent. She said, quote, it may be that the legislature envisages the legislation hereof in the future, but this does not mean that the court should anticipate it. The legislation of dealing in cannabis concerns policy issues and falls within the realm of the legislature, not the judiciary, unquote. Operating a Grow Club is, for now, a criminal act in terms of the Drug Trafficking Act, and conviction can lead to imprisonment. As far as we can tell, this applies to those operating the clubs and not the individuals whose plants are grown there. Currently, cannabis falls under Schedule 2 of the Drugs and Drug Trafficking Act. The Draft Cannabis for Private Purposes Bill proposes to remove it from this act, which would mean the Drugs Act would no longer apply to cannabis. At that point, only the Medicines and Related Substance Act will apply to cannabis. We have yet to see whether cannabis grow clubs will fall under medicines regulation or whether there will be specific legislation enacted to deal with the clubs. All I can say is this: watch this space. I'll keep you updated with relevant legal news. Meanwhile, if you have any questions about or queries about cannabis legislation or any other aspect of the law, please give me a call on the number in the signature below.